All right, so have you ever had a brilliant idea and then wondered, hey, what stops someone in another country from just taking it? You write a book, you invent something amazing, what keeps it safe? Well, today we're going to journey through the legal history of exactly that. We're going to see how the world built the rules to protect the creations of our minds. It's a pretty fascinating story. So let's kick things off with the big question, the one that kept inventors and artists up at night for decades. I mean, think about it. As the world got smaller, as trade and ideas started zipping across borders, you had this huge, glaring problem. How do you protect your work once it's out there, beyond your own country's laws? And honestly, before we had these international rules, it really was the Wild West. Imagine patenting an invention in France and then finding out it's completely unprotected in Germany. You could write a bestseller in London, and someone in New York could just copy it, print it, and sell it without paying you a dime. Protection literally stopped at the border. For a world that was industrializing and globalizing, this was total chaos. Something had to give. And that chaos, that's what really lit the fire. It forced people to come together and say, okay, we need some rules of the road. And what emerged were two, let's call them foundational pillars. These two agreements became the bedrock of the entire global system we have even today. Okay, so take a look at this timeline. What's absolutely wild is how quickly this happened. Paris in 83, Berne in 86, Madrid in 91. All of these foundational treaties popped up in less than a decade. That's not a coincidence. It tells you just how desperate everyone was for a solution. The need wasn't just there, it was urgent. Now, here's what was so clever about their approach. They didn't try to boil the ocean and solve every single IP issue at once. Nope, they created a clear division of labor. You had the Paris Convention, which was all about industrial property. Think patents for inventions, trademarks, all that good stuff. And then you had the Berne Convention, which focused on literary and artistic works. Your books, your music, paintings, you name it. One for industry, one for the arts. Simple, right? And the absolute core principle, the engine that made both of these conventions work, was this brilliant idea called national treatment. I mean, it sounds simple, but it was revolutionary. The rule was this. Whatever protections you give your own creators, you have to give to foreign creators too, no exceptions. So an inventor from the US would get the exact same patent protection in France as a French inventor would. It was a game changer. And the Berne Convention, the one for artists and authors, it actually took things a step further. It wasn't just about national treatment. It also set up minimum standards of protection. Think of it like a safety net. It guaranteed that no matter which member country an author's work ended up in, there was a baseline of rights they could always count on. This was absolutely huge for creating modern copyright as we know it. Okay, so we've got the foundational principles, right? National treatment, minimum standards, that's a great start. But, rules on a piece of paper are one thing. You need a system to actually manage all of this. So that was the next big challenge, building a truly global system. And the solution was, to create a central office, a hub for everything. So in 1893, they took the administrative bodies for both the Paris and Berne conventions and united them. And just like that, the World Intellectual Property Organization, or WIPO as we call it, was created. This became the central command, the one-stop shop for all things international IP. But of course, solving one problem often reveals another one, right? So now you have these great principles, you have a central organization, but if you're an inventor, you still have a massive headache. Imagine trying to file a patent in, say, 10 different countries. That's 10 different applications, 10 different sets of rules, 10 piles of paperwork. It was an administrative nightmare. It took a while, but a solution finally came along in 1970. It was called the Patent Cooperation Treaty, or the PCT, and it was just brilliant. Look at these steps. Instead of drowning in paperwork, you could now file a single international patent application. That application would go through one international search, and only after that, you'd enter the national phase and pick and choose the specific countries where you actually want the patent. It streamlined the whole messy process beautifully. Okay, let's pause here, because we're about to get to the single biggest, the most significant development in the entire history of modern international IP law. If Paris and Berne laid the foundation, this next agreement, it built the skyscraper on top. This was the 1994 TRIPS agreement, and what it did was fundamentally change the game. It yanked intellectual property out of these sort of quiet, niche legal circles and smashed it right into the middle of international trade. All of a sudden, IP wasn't just a legal issue anymore. No way. It was a core part of global trade policy. And here's why that mattered so much. TRIPS was administered by the World Trade Organization, the WTO. This gave the rules real, actual teeth. It made strong IP protection a requirement for being part of the global trading system. The message to countries all over the world was loud and clear. You want to trade with us? You want to be part of the global economy? Then you have to protect intellectual property. So what did TRIPS actually do? Well, it had these key features that made it so powerful. First, the scope was massive. It covered pretty much everything: copyright, patents, trademarks, even trade secrets. Second, it set those minimum standards, just like Berne, but made them enforceable. It kept the national treatment principle, of course, but it also added this really important most favored nation rule, which basically means you can't give a special IP deal to one trading partner and not the others. No playing favorites. And get this number, 73. That's how many articles are in the TRIPS agreement. 73. That tells you just how detailed and comprehensive this thing was. We're talking about a full framework for everything from how patents are granted to how you enforce your rights in court. This was really the moment that IP law went from being a patchwork to being a harmonized global system. And as always, technology doesn't stand still. Just as the ink was drying on TRIPS, the internet was exploding. So, in 1996, we got the WIPO Copyright Treaty. People call it the Internet Treaty because that's exactly what it was for. It was a crucial update to the old Berne Convention designed to tackle the new digital world, things like online piracy and how to protect computer programs. So that's a whirlwind tour of over 100 years of legal development. So where does that leave us today? What does this whole framework actually look like when you put all the pieces together? Well, what we have is a system with a few key layers. At the bottom, you've got that solid foundation of the Paris and Berne Conventions. Then you have WIPO acting as the central administrator, kind of the air traffic control for the whole thing. You've got tools like the PCT and the Madrid system that streamline the process and make it easier for creators. And then at the top, you have the muscle, the enforcement power that comes from the WTO and the TRIPS agreement. It all works together. And I think this quote from TRIPS itself really says it all. The point of all of this, it's not just about protecting inventors and authors. The real goal is to promote innovation in a way that's good for everyone, that helps social and economic welfare. It's a balancing act, and it's an incredibly important one. Which brings us to the big, provocative question I want to leave you with. This entire framework we've talked about, it was built for a 19th century world of industry, and then it was updated for the 20th century digital age. But is that framework ready for the challenges of today? For a world where AI can create art and data can circle the globe in an instant? I think it's safe to say the evolution of IP law is a long way from being finished.